The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures of whatever nature and for any purpose shall be inviolable, and no search warrant or warrant of arrest shall issue except upon probable cause to be determined personally by the judge after examination under oath or affirmation of the complainant and the witnesses he may produce, and particularly describing the place to be searched and the persons and things to be seized. Section 2, Article 3 of the 1987 Constitution.
This provision protects the right of every individual against unreasonable searches and seizure by state or government authorities. The general rule is that no arrest can be validly effected without a warrant of arrest, and no search can be effected against our persons, houses, and belongings without a previously issued search warrant by the courts. An arrest or search warrant can only be valid when it is issued by a judge of a competent court after probable cause and evidence is determined personally by said judge by examining under oath the complainant and the witnesses he may produce against the person to be arrested and to be searched. Take note that the basis for the issuance of a warrant of search or arrest is probable cause. Probable cause has been defined as those facts and circumstances that would warrant a cautious man to believe that an offense has been committed and that a person is probably guilty thereof. However, the law recognizes some exceptions to the said rule. Section 5 of Rule 113 of the Rules of Court provides for the provisions of valid warrantless arrest. This is the recognized rule on citizens' arrest. The rule declares that any person can make an arrest without a warrant when, number 1, the person arrested is about to commit or is in the act of committing an offense in his presence. Second, when a crime has just been committed and he has personal knowledge of facts indicating that the person to be arrested has committed it. And thirdly, in the case when the person to be arrested is a prisoner who has escaped from a penal establishment or temporary confinement while serving final judgment or while his case is pending or while being transferred from one confinement to the other. In one memorandum, the Supreme Court also allows warrantless arrest on an accused in any port or airport wherein he attempts to leave the country without previous permission of the court where his criminal case is pending. Of note is the strongly dissented and controversial case of Umel versus Ramos, wherein the Supreme Court declared that in the case of rebels, they can be arrested anytime without warrant of arrest because rebellion is a continuing offense, and even if they are not in the actual act of rebellion, like in the case of being confined for treatment in a hospital, they can be validly arrested without a warrant. It's because in that case, given the status of rebellion as a continuing offense, they can be considered to be still actually committing said crime under the context of Section 5, Rule 113 of the Rules of Court. On the other hand, by jurisprudence, search without search warrant may be allowed when, number 1, there is personal waiver or consent on the part of the person searched. Second, when the search is incidental to a valid arrest, wherein a person validly arrested may be searched of his body or things in his premises and surroundings within his immediate control. Third, the stop and frisk rule, wherein the police officer may be allowed to frisk a person acting suspiciously to search for possible weapon in his possession and control. This doctrine originates in the decision of the U.S. Supreme Court in the case of Terry versus Ohio and is adopted by our jurisprudence in the case of People versus Posadas, wherein the Supreme Court affirmed the validity of a warrantless search of a beauty bag which contained firearms conducted by lawmen in Davao City against persons who acted suspiciously upon being approached by them. Fourthly, searches of moving vehicles in borders and constructive borders of state. In the absence of probable cause, searches of vehicles in the interior territory of a state cannot be justified. It can be validly done only within the borders and constructive borders of a state. However, if probable cause exists upon the census of the searching authority, even in the interior jurisdiction of a state, warrantless search can be made upon a moving vehicle. So that in the case of Balmonte versus De Villa, the Supreme Court, in a strongly dissented decision, affirmed the authority of the state to establish checkpoints, while it made clear that its authority to check passing motor vehicles is limited only to visual search, unless there is probable cause, in which case extensive warrantless search may be allowed. The problem, however, is the determination of such probable cause now rests not upon the judge, but upon the authority manning the checkpoint. Warrantless search is also allowed to seize prohibited articles in plain and open view. Searches upon aircrafts and vessels to implement immigration, customs, and drug laws is also allowed by the Supreme Court in a lot of its decisions. And lastly, inspection of buildings and other premises for the purpose of enforcing sanitary, fire, and building regulations is also allowed without search warrant. Even if there is a validly issued search warrant, search can still be questioned when the conduct of the search is irregular or when objects not mentioned in the search warrant, other than contrabands and prohibited articles, are seized. Any evidence obtained as a result of an illegal and unreasonable search cannot be admitted as evidence in court for whatever purpose and in any proceeding. Authorities conducting an illegal search or arrest may be held criminally, civilly, and administratively liable. However, if the person making an illegal search is not a government authority, but a private individual acting upon his own private initiative, as decided by the Supreme Court in the case of People versus Andre Marte, any object seized as a result thereof may be admitted in court even against the accused, as the exclusionary rule in the Constitution is only a prohibition on the presentation of evidence illegally obtained by the state or its agents, and not by private individuals acting upon his own private initiative.